Good afternoon, friends. Let us solve question 5, paper 1, Advocate on Record Examination 2019. It says, Order 5 of the Supreme Court Rules 2013 provides for business in chambers and vests certain powers in a single judge sitting in chamber, known as chamber judge, and also in the registrar. Describe the types of pleadings which can be heard by a single judge sitting in chamber and proceedings which can be heard by registrar. Does the chamber judge have an appellate power? This is the question which I am going to answer. Friends, now first of all, take first part, power of the court in relation to following matters may be exercised by a single judge sitting in chamber. First power is application by advocate on record for leave to withdraw or for change or discharge of an advocate on record. Second one is application for leave to compromise or discontinue an appeal where permission was granted to sue as an indigent person. Third one is application for striking out or adding parties or for intervention in a suit, appeal, or other proceedings. Fourth one is application for separate trial of causes of action. Fifth one is application for separate trials to avoid embarrassment. Sixth one is rejection of plaint. Seventh one is application for setting down for judgment in default of written statement. Eighth one is application for better statement of claim or defense. Ninth one is application for particulars. 10th one is application for striking out any matter in a pleading. 11th one is application for amendment of pleading and for enlargement of time to amend any pleading. 12th one is application to tax bills returned by the taxing officers. Then comes application for review of taxation. Then application for enlargement or abridgment of time, except application for condonation of delay in filing SLPs. Then comes application for issue of commissions, application for assignment of security bonds, questions arising in taxation referred by the taxing officer, application for orders against clients for payment of costs, application for taxation and delivery of bills of costs, and for delivery by an advocate of documents and papers, application for registration of advocate as advocate on record. Friends, I am repeating important power. That is application for registration of advocates as advocate on record, application for leave to proceed as an indigent person, application for grant of bail where the petitioner is confined in jail for offenses punishable with imprisonment up to 7 years. I am repeating this power, important power. Application for grant of bail where the petitioner is confined in jail for offense punishable with imprisonment up to 7 years. Application for stay of execution of a sentence or order in criminal proceedings. Application by accused person in custody for being produced before the court at the hearing of the appeal. Consent application in interlocutory matters, application by accused persons for engagement of advocate, fixing the remuneration of the guardian and litem, summons for non-prosecution, which includes the power of dismissal for non-prosecution, office report on default. I'm repeating the important provision. Office report on default, application for exemption from paying court fee or extension of time for paying court fee or for furnishing undertakings, bank guarantees, or security, application for substitution, application for condonation of delay in seeking substitution, and application involving setting aside abatement, application for condonation of delay in refiling where the delay exceeds 60 days from the date of notifying the defects, application for refund of security, application for withdrawal of any appeal, petition, or suit with the consent of all the appearing parties or where the other side has not appeared, application for exemption from surrendering, provided not more than one opportunity be granted for surrendering in case of refusal and or if accused does not surrender, the matter be placed before the Honorable Judge in Chamber for non-prosecution, issue of fresh summons and notices, application of a person who is not a party to the case, appeal, or matter for inspection or search or grant of copies for good cause shown, application by third parties for return of documents, application to appoint or discharge a next friend or guardian of a minor or a person of unsound mind, and direct amendment of the record thereon. Important provision is this. Application to appoint or discharge a next friend or guardian of the minor or person of unsound mind, and direct amendment of the record thereon. Application for consolidation of appeals and writ petitions for purposes of hearing and preparation of record, application for amendment of pleadings with the consent of all the appearing parties or where the other side has not appeared. Now, friends, go through second part of the question. The powers of the court in relation to the following matters may be exercised by the registrar. So, I am discussing about the power of the registrar. Application for discovery and inspection, application for delivery of interrogatories, application for substituted services, application for time to plead, for production of documents, and generally relating to the conduct, cause, appeal, or matter. Application for leave to take documents out of the custody of the court. Questions arising in connection with the payment of court fees. Application for the issue of certificate regarding any excess court fee paid under a mistake. Application for requisitioning records from the custody of any court or other authority, application for condoning delay in paying deficient court fees, application for condonation of delay in filing statement of the case, provided that where the registrar does not think fit to excuse the delay, he shall refer the application to the court for orders. Application for appointment and for approval of the translator or interpreter, application for withdrawing of appeal by an appellant prior to his lodging the petition of appeal, application for production of documents outside court premises, application for payment into court, application for payment out of court of money or security or interest or dividend on security, application for extending returnable dates of grants, application for refund of security deposit or part thereof, or for payment out of security deposit application for direction regarding preparation of record, application for exemption from filing a certified copies of the judgments, decrees, orders, or certificates, or order granting certificate, provided that application for exemption from filing of certified copies of judgments and orders accompanied a special petition shall be posted before the court along with the special petition. Application for condonation of delay in refiling, provided the delay does not exceed 60 days from the date of notifying the defects. Application for condonation of delay in filing process fee. Application for extension of time for filing pleadings, provided the registrar shall not grant more than one extension for the purpose exceeding 4 weeks. Application for cancellation of date on the written request of the appearing parties, provided the matter has not appeared in the final cause list on the date of filing of the application. Office report for removal of fixed deposit receipts and bank guarantee subject to directions otherwise by the court. Application for exemption from filing official translation. Application for exemption from filing process fee and or spare copies. All uncontested interlocutory applications of formal nature, any matter which in accordance with the order or direction issued by the court is required to be dealt with by the registrar, imposing costs on the party in default of compliance of the orders passed by the registrar. Pre-final hearing matter to certify the matter is ready for in all respects to list the same before the court for final hearing. Now, friends, coming to the appellate power of the chamber judge. So, friend, it is any party aggrieved by an order made by the registrar under this order may, within 15 days of making of such order, appeal against it to the judge in chamber. So, friends, this is the appellate authority of the chamber judge. I am repeating, appellate authority of the chamber judge. Any person aggrieved by an order made by the registrar under this order, that is order 5, may within 15 days of making of such order appeal against it to the judge in chamber. So friends, this is video relating to the question, very important provisions are therein. You please read 2 to 3 times, listen it thoroughly, be settled, and